I'm attorney Charles Kronzek. If your family law case, your divorce case, involves the custody of a minor child, here's what you need to know. An initial custody determination begins with an analysis of the status quo. What's been going on? Is there a primary caregiver for the child, a primary parent, or are the duties pretty equally shared? Because the court needs to make a determination as to whether or not a proposed new custody order will change the status quo or the established custodial environment. That sets the bar for the more important analysis that every judge has to do before custody is decided. That's called an analysis of the best interest of the child factors. So where more factors may favor your spouse or you, the court may feel that some are less important than the others. It's not okay and it's not safe just to say who has more factors or less factors in their favor or against them. But in any event, it's required that those findings be done on the record. The initial determination for a temporary custody order is made at a conciliation conference, which is held at the friend of the court. Most of the time, attorneys are not present for those conferences, but from time to time, I make a determination that we are needed to be there. So either I or one of our family law attorney team members may be present. Once the initial custody recommendation is made by the friend of the court's investigator, it will be signed by the judge and you'll have a temporary custody order. Either parent can object to that custody order, and the attorneys do the objections in a specific format. Once the objections are filed, you move on to the very first important custody hearing, which is a full-blown evidentiary hearing. That's something that you need to talk with your attorney about and plan for well in advance. It sets the stage for the rest of your custody case.